It's now 11 o'clock, and we have a special meeting planned for today. Can we have the pledge to the flag as we start most meetings? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Can we have the roll call, please?
Councilmember Carlson?
Here.
Councilmember Dobby?
Here.
Councilmember McKeithen?
Here.
Vice Mayor Lewis?
Here.
Mayor Whitmer?
Here. Okay. Now we'll have public comment. Unlike other meetings, this section is going to be limited only to the items that are actually on the agenda, the two that are printed and in the back. Do we have any public comments? Herm?
I don't know whether this is appropriate, but I thought I'd like to address you on the subject of picking another town manager and give you some of my thoughts, which result from a experiences as chairman of the board of Menlo Park School District and later as chairman of the board of a private school and finding a headmaster. I think all of you recognize the difficulty of finding an energetic, effective town manager for a small entity. The problem is basically that the energetic person that you want probably has higher aspirations, wants to go to a larger organization, and you also face the problem of those who want to float have a record, and it's very difficult to find. So I can only urge you to find as your consultant someone who knows a lot of people in the system, because the person that you want is probably employed somewhere at this point, and you're going to have to recruit him rather than find him through a classified ad or some way like that. So I can only, as a citizen, wish you good luck, and I hope you're successful in finding that town manager, which is, I think, the #1 task right now.
Thank you. Are there any other public comments? Okay, seeing none, we'll move on to the regular agenda. First order of business is approval of a resolution appointing the interim city manager. I guess we'll go to Mr. Connors, who's a staff member who prepared it, to explain.
Mr. Mayor, members of the council, before you is a suggestion that the city council appoint the interim city manager, the deputy city clerk, Teresa Della Santa. Staff believes that she's qualified, capable, and has an incredibly supportive professional staff behind her. It is for an interim position, and it does include an adjustment in salary as set forth in the resolution. And beyond that, if anybody has any questions, we'd be happy to answer them.
Council?
No questions? No questions.
I have a comment. I hold a Deputy City Clerk, Teresa Della Santa, in a very high regard. I think over the last 3 years, she has proven to the town, to staff, to council, that she is confident, she's capable, she is eager, she's energetic, she's willing to learn, she's been going to school after hours, she is efficient, and she can rise to this occasion on a short-term interim basis. However, I do have concerns about her salary compensation, and honestly, this is the first that I really received. First thing this morning, I received this resolution with this salary compensation, and while on the surface it looks like it is a generous increase, to her. However, if she is to be doing this city manager's job as well as her job as city clerk, it seems short on funds. That's a double job. I understand that this is going to be on a short-term interim basis. I'm also concerned about protecting her from any adverse situations that may arise from putting her in this position and potentially jeopardizing her future. So I want to make sure that council and staff and all the public rally around her and give her all the support and protection that she will need for this interim basis.
Gabby?
In response to Elizabeth's comment, I believe that Teresa will have to hire, as interim city manager, other people to assist her and take over some of the responsibilities. John is shaking his head so that she is not going to actually be performing a double job. With regard to the resolution, I would request one small addition, and that is that in the final clause before the certification of the resolution, that we, in the second line, on a transitional basis with a temporary salary adjustment, we do that. Insert the word temporary, please.
As a comment back, I don't think our microphones are working anymore, but as a comment back, it was not, I have not been informed that additional staff would be hired. And so I don't see that as part of this staff report or as part of this resolution. So if other council members have knowledge that I don't have about that, I'd like to hear it.
Yeah, Mr. Mayor, maybe I can clarify. We have no crystal balls. We have a very, as you put it, and I agree, an energetic, enthusiastic person ready to take on this challenge. As city manager, she will have the same authority that all the past city managers have had. And that includes, within a very limited degree, the ability to hire temporary personnel to assist her. The same way that the city manager last month had, and the same way that the city manager a year ago had, and 2 years ago had, our purchasing ordinance or personnel ordinances allow for if, for instance, an election comes along or she needs someone to stuff envelopes, she's always had, the city manager's always had that ability, and she will have that same ability going forward. We didn't feel it was necessary to appoint anyone or present anyone, but the city clerk slash hopefully interim city manager recognizes that she may need someone to, for instance, to sit back and take minutes and to record meetings, and that will definitely fall within her prerogative, and I'm sure that she will take advantage of that.
I have no objection to that. I'm wholeheartedly in favor of that.
I would like to say also that certainly I think Teresa's done a wonderful job since she's been here, and that I'm sure all of us as council members are willing to help her. I think maybe, however, we want to be careful that we don't try to take over any of her responsibilities because she is the interim city manager. So if she requests assistance from any of us, I'm sure that will be available. But on the other hand, it's going to be her job and her decisions to make, and to the extent that we can help, that's great. But I think the extent that we interfere, I think that's not something we want to do.
Yeah, big
Stephanie, anything else?
No, I think we all just have to hang together in this, support our new interim city manager, and stay out of her way.
So there have been some questions on how we arrived at the salary. So can anybody walk us through the logic on the salary level? Not necessarily because there's taking on additional jobs. We need to, obviously, we need to pay for what people are taking and their responsibilities. But there have been some questions from the public on how did we arrive at the number, and honestly, there's not any information on that. So Bill.
Mr. Mayor, it's not exactly rocket science. Essentially, all salaries that you pay all of your employees, in a sense, are negotiated. Except for the rank and file employees, where actually it's still negotiated with the union. And so bottom line is, there was a negotiation that occurred between, I believe there were several parties involved, the outgoing city manager and the city clerk. I think that the mayor was probably involved in discussions, but the bottom line is, this is a number that the city clerk has agreed is a fair number to represent, a person with limited experience, but incredible drive, desire, and brings a lot of things to the table, and where she may be lacking in experience, there are those around her, including the other recommendation on the agenda today, the hiring of somebody to give her counsel when needed on it, and when she needs it, not when he wants to give it, but when she needs it. And I think the other comments that the council gave were very, very pertinent in terms of, it really is the city manager that runs cities under the council city manager form of government, and this salary is supposed to reflect the increase in responsibilities. Now, there could be much longer days and nights as she gears up for answering all the questions that will come from you and from the public. So,
And it represents approximately, so just so the public knows, approximately a 25% increase over
that's correct.
her present salary.
All right, are there any public comments with regards to item number 1 on the agenda? Seeing none, we'll come back.
I will make a motion that we approve the resolution 12XX appointing an interim city manager.
With the word temporary inserted?
Temporary, appointing a temporary interim.
No, with the
city manager.
word temporary
No,
before
temporary
salary.
salary.
Oh,
Yeah,
okay,
and Kevin.
all right.
I'll second that.
Okay, all in favor?
Aye.
Opposed? Motion passes.
Welcome.
So, do you want to move up now?
Well, in case there's public comment, I think here.
You can run back and forth. Okay. Okay, next item on the agenda is a discussion and approval of a consulting agreement with Mr. Danielson to provide consulting services and recruiting services for the town. So, Bill, would you like to,
There's just one. Is there
Those two.
correction there?
or will Bill discuss?
Oh,
So, Bill?
Yeah, Mr. Mayor, members of council, there is an error on the face of the agenda. It says that the recommendation is to retain Mr. Danielson on a month-to-month basis in the amount of $14,000 per month. That's wrong, it's $12,000. And the latest iteration of the agreement, that was unfortunately, I apologize, hammered out late last night, does indicate that the scope of services is split into two. There are two primary facets to the agreement. One being the executive search for a new city manager, and that carries with it a compensation of $5,000 a month. And the other is to serve as an on-call resource consultant to the interim city manager at $7,000 a month, for a total of $12,000 a month. And the concept is not just clear, it is not a sham, it is not in any way intended to be anything other than what it says. And that is, there are two functions that will be provided. Mr. Danielson will no longer supervise, direct, manage anyone. He cannot, in fact, he's prohibited from doing so. And in conversations with both Mr. Danielson and the new interim city manager, Teresa Della Santa, it has been pointed out this person will be a resource, and one that that she can lean on and ask questions of, and requires him to make himself available and provide good and competent, qualified responses to her. So we think this is a way of meeting the sudden response from PERS that requires us to take these actions, and gives the town the ability to handle two very important functions right now. One, getting a permanent city manager quickly, but one, I think as Herm indicated from the public, one that, for somebody that has knowledge of what the council needs and wants and what will fit in this community well. And the other aspect of it is he is probably in the best position to advise the new interim city manager because he's been there and has institutional knowledge of what goes on in the personnel and personalities. And I think that based on that, this was staff's recommendation to the city council, and we think that the contract provides ample evidence for the public and for CalPERS that this is a true consultant position and nothing more.
Okay, so this was put out very late or very early, and I don't think anyone really had a chance to really read through it. So since you are the author of the agreement, would it be possible that you could walk us through the provisions, please?
Sure, this is kind of utilizing my standard consultant agreement. And basically, as you go through the provisions, the scope of services are set forth in Exhibit A. And I don't have it in front of me, but I know that it says basically the two main functions that I've outlined for you. If it's in front of me, I don't know where
Exhibit
it
A
is.
is.
Oh,
It's in your pack. No.
Okay.
Oh, yeah, it is.
Here it is.
Exhibit A says very plainly, general scope, retain and provide professional consulting services limited to conducting a search for new city manager and provide on-call services to the new interim city manager as directed by the interim city manager, and specifically not acting on behalf or directing, etc.
And through the chair, it's more detailed under section 2, page 1 of the agreement, scope of services.
Mayor,
Yes.
if I might, I did read this agreement in the last hour before this meeting, which is when most of us received it. If I might, could I give you my comments on the agreement, and then the city attorney can go through it. But I'd like to present my comments on the agreement first, generally, so that when our city attorney goes through the agreement, he might be able to address my comments as well, if the council doesn't mind.
Bill, you
It's
okay?
fine with me.
All right, we'll do that. That's fine.
Before I get to the agreement, I just would like to ask, we have this problem basically because CalPERS rejected our letter requesting an extension of John's working agreement. Did we not know that, and because CalPERS, the law changed January 1st, and CalPERS didn't look at our letter until January 2nd. Didn't we foresee that the law was going to change on January 1st?
In a word, no. The legislature passed about, in any given year, several thousand pieces of legislation. And usually the League of California Cities presents those to city attorneys. And unfortunately, that usually doesn't happen until around the first of the year, and it hasn't happened yet this year. It will happen in the next month or two. This was not new legislation. This was clarification of existing code sections. There was much ambiguity in the previous version of it that they clarified, and the fact that they clarified it should serve as indication that it was ambiguous. Otherwise, they wouldn't have done so. And it was not clearly understood. We, relying on what other cities had done previously, submitted to CalPERS a request for a 12-month extension. They came back and said, you're reading the statute wrong, but it doesn't matter because it's been clarified now. And in my conversations with the person at PERS that's in charge of this, she was very adamant that this is not necessarily a rare occurrence for someone to request this, because the way the code section reads is essentially it's talking about extending the hours, but then it says, you know, you can have one extension for 12 months. And it was unclear. The new statute that went into effect January 1st, that by the way, caught this contract by at least 1 day, regardless of what anybody says. It applies to the John's contract that extended to January 2nd. Clearly says that regardless of what statute you use, 21-221 or 21-224, regardless of which, the total amount that you can have as an interim in any position is limited to 12 months. It didn't say it that way before, and it does now. So were we surprised? Yes, we thought we were acting within the scope of the statute. It was ambiguous. CalPERS, in their mind, doesn't think it's ambiguous, but it doesn't matter because the new law is applicable to this contract because it extended past the imposition of the new statute of January 1st.
And we had no heads up from anybody that, I mean, that sounds like a change in the law, that where you're allowed one extension of a 12-month period, and come January 1st, you're allowed no extensions whatsoever.
It didn't say you were allowed a 12-month extension before. What it said in an ambiguous paragraph, they say that it allowed you to exceed the 960 hours in the 12 months. That when it said you're allowed one extension, they said their understanding of the statute was that it applied only to the hours.
I see.
And also there were companion statutes that they cannot explain satisfactorily to me why when one expired you couldn't use the other. In fact, that's what a lot of cities were using to hire people interim for 2-year periods, and CalPERS was frustrated because they couldn't enforce their interpretation of the law until the legislature clarified it. And now there's no discussion. It clearly states for the first time, when you add the two statutes together, it's still 12 months period.
Got it. Okay, scope of services. It says the general nature of the services include, this is in section 2, undertaking of personnel search and recruitment and acting as an on-call advisor to the new interim city manager. I have a problem with that. We had agreed as a council at our last council meeting that we would do the recruitment in order, in part, to save the cost. We did authorize an allowance of approximately $10,000 for miscellaneous costs such as advertising and travel and things like that. With this agreement, adding $7,000 or $5,000 a month, that's another $15,000. We're already up to $25,000 for the search. And we don't really know what the services to perform for the search and recruitment are, whereas before, when we actually hired a search firm, we actually had 10, 12, 15-page document outlining what the nature of those activities was going to be. So I don't exactly know what the consultant in this case is going to be doing as compared to what the city council is going to be undertaking when it said it would undertake the search at its last meeting. So how the nature of those two activities is going to fit together, I don't know. We have all the materials from the last several recruitments. We have conducted the search for the last several recruitments, so just what would be the consultant's job here? That's one question. I don't expect them all to be answered, but as we go through. Another thing is acting as an on-call advisor to the new interim city manager. We need someone who's here. We need someone to know someone who's here at what time, what hours, and I believe that the interim city manager can count upon. And I believe it's possible to wrap up those the recruitment and search activities as part of that consultant to the interim city manager, rather than as a separate job, while we have those established hours. Moreover, I'd like to know exactly what those sort of activities might be, and in particular, I'd like some indication of what we have on our plate for the next 3 months. This happened very suddenly, and I'm aware that it's no one's fault, but given the fact it's happened so suddenly, we as a council have no idea what is forthcoming for the next 3 months. I don't know where things are. Things have been held very close to the chest, both with regard to the sort of activities that might present themselves for our next 3 months' agendas, as well as what the litigation status and activities are. And I'd like to know where all that stands and where the role of the city manager might be in that, particularly when we get down to section 3, which says that the consultant would be reimbursed an additional $500 per day or any portion thereof for any additional work or travel related to matters of litigation. Any additional work. Now, that means that if one of the litigants, who happens to be a resident of the town, we know, calls or sends an email, reviewing that email, is that any additional work that we'd have to spend an additional $500 per day because it involves our former interim city manager? I don't know. So I would like to know exactly what the outstanding litigation is, what we're talking about there, and I also can't help but wonder, shouldn't some of that be subsumed in part of the consultant activities? It says, with regard to each general type of service outlined in the scope under compensation, that it will be broken down. But again, I don't know what these specific recruitment services are. And when in B, it says that we'll receive an invoice as to determine whether the work performed and the charges made are in compliance with the provisions of this agreement. If someone submits an invoice saying, I put out an ad, I've done recruitment, pay me $5,000 or $7,000, $5,000, and I've advised Teresa on this matter, pay me $7,000, that to me would be all we could require. There really wouldn't have to be any more that we could ask, and we would be required to pay for that consultant. So I don't know what B adds to that, and that's why I think we really need some established hours and enumeration of what work we're asking be performed. Under subsection E, it says, however, the recruitment and responsibility is expressly terminated and is no longer a requirement attached to staying at the premises. This is regard to staying in the house. What it's essentially saying in that paragraph is that the consultant may stay in the house even though he's no longer going to be acting as city manager. We long ago received multiple opinions that the house is not tax-free unless the person acts as city manager and basically an overseer of the park at the same time, which means that as of the day that our city manager ceased being city manager, that property became taxable. And perhaps an adjustment could be made. I understand that our interim police chief lives there. Maybe this is something that we could transition and have the police chief live there and as overseer of the park, and if he so desires, allow the consultant to live there as a guest, which would certainly thereby alleviate the consultant's need to pay taxes on that property. That might be something we would want to consider as a means of avoiding taxable property to the consultant. On page 3, status of consultant. The personnel performing the services under this agreement on behalf of the consultant. I realize you used your standard consulting agreement, but we don't have any personnel performing the services under the consultant, and I think that should be eliminated. Under section 11, the non-discrimination provision, I don't know if you're talking about the consultant will not discriminate against any employee or applicant when you talk about applicants for the job of city manager, or if you're talking about consultants' employees. I assume you're talking about the consultant's employees, but inasmuch as we do not want the consultant to delegate and thereby do not want the consultant to have any employees, I think that whole provision should go out, as should the entire section 12 with regard to aliens. It's not applicable to us. With regard to section 13, it says consultant further covenants that in the performance of this agreement, no person having any such interest shall be employed by him as an officer, employee, or sub-consultant without the express written consent of the town's city manager. Well, I guess that's okay, but I don't know that we want anybody to be a sub-consultant, and it's something we should consider. We certainly don't want subsection B, which says that the town understands and acknowledges the consultant is unaware of any stated position of town and can take other projects. Do we really want our consultant to be, we've already had this issue with regard to other people who work for the town involved in other projects even though he may not realize he has a conflict of interest on other things he might be doing. Think about that. And section 14 talks about us indemnifying the consultant for negligent performance. Do we want to be indemnifying for negligence? Subsection 15 says the town acknowledges its consultant may utilize sub-consultants. Again, that isn't what we want. We don't want sub-consultants, and it shouldn't be in there. And that is the beginning of my comments about this agreement. I essentially believe that it should be a single agreement, but I believe it should be a single agreement, not for someone who's doing search for the town, but for a consultant. It should be specific hours. It should be for specific enumerated responsibilities, which would include recruitment, assistance to the council, and it should be specifically enumerated what is being left undone and remains to be accomplished, and what the status of our litigation is. Those are my thoughts.
Mr. Mayor, there's a lot there that I'd like to go through, and
Which I think basically means, I think that we need to put this agreement aside for a while and think about rewriting it.
well, let me, if it's up to the council, but let me explain some fundamentals here. Number one, you cannot dictate specifics. That's what you do with employees. If you do, it loses its consultant status. In fact, by law, a consultant has to be given a task, and you cannot supervise or they become your employees. PERS prohibits us from hiring Mr. Danielson as an employee. He's already been allowed to serve for a year. We cannot hire him as an employee right now unless we do it as a PERSable employee. For instance, you can hire him to be the finance director and pay PERS and all the other things. So you cannot give him specific hours, times, places to be. That violates all of the IRS and the EEOC and other regulations that specify the difference in a consultant and, in fact, an employee. This contract was carefully drafted to not step over that line and subject us to penalties from PERS for making it and taking somebody who's really being an employee and saying they're a consultant. If that's what the council wants to do, we will have to change this into making him an employee, and you will pay an additional 25% or so on top of that to PERS, and he would have to come out of retirement. I'm not sure Mr. Danielson would want to do that. He will not work for the town. He will be a consultant to the town. The scope that the city clerk included, unfortunately, I emailed several scopes up to her in the middle of the night last night, and we crossed wires, and I did not have an opportunity to look at the scope. I focused on the agreement this morning. But I will read you the scope that I sent up that should be included. The one that's with your packet is incorrect. And Councilmember McKeithen is correct. It is a little bit limited. This is the one that should be attached, and I would suggest that if the council wants to move forward, this be the scope. And I will read it. Because normally I wouldn't, but for time reasons I will do that. The scope of services applicable to that consultant contract by and between the town of Atherton and John Danielson dated January 27th, 2012 shall be as follows. 1. Executive recruitment services. Consultants shall provide executive recruitment services for a permanent city manager for the town. Such services shall include creation of appropriate advertising, interviewing individual council members to determine the requisite qualities, skills, and qualifications necessary for this position, assessment, screening, and evaluation of applicants with respect to council qualifications and expectations, and assisting the city council with interviews, negotiation of compensation, and background checks. Consultants shall act independently from the interim city manager and shall not provide any managerial services other than as set forth in this paragraph. Compensation for this service shall be the sum of $5,000 per month and shall not exceed 3 months without prior city council approval. 2. Advisor to interim city manager. Consultants shall be available to the interim city manager for consultation and advice on an as-needed basis and only as requested and under the direction of the interim city manager. Such advice may provide a historical or analytical perspective, common management practices, labor relations and personnel advice, and such other similar advice and counsel as requested by the interim city manager. Consultant is prohibited from acting in any capacity as a city manager, from directing any employees, officers, agents, consultants, or from giving advice directly to the city council or any town employees. The services provided under this section shall be advisory to the interim city manager only and shall be expressly confined to that task as outlined herein. Any provision of normal or, quote, common law, end quote, city manager services shall void this agreement. Consultants shall be available on a daily basis, either personally or by telephone, but shall not have a regular office in City Hall. He may use such facilities from time to time as needed, but shall not regularly work out of that office. Compensation for this service shall be the sum of $7,000 per month and shall not exceed 3 months without prior city council approval. 3, intent of this agreement. Consultant has previously served in the capacity of interim city manager for town. It is the express intent of this agreement as outlined in this scope of services that consultant not continue in any manner in that previous capacity. The scope of services outlined herein are intended to be separate and distinct from any previous duties performed as the interim city manager and are intended to relate only to the tasks and duties outlined herein and to prohibit and restrict consultant from performing any of the normal and routine duties of managing or running the town as its city manager. He shall work separately, not manage employees in any way, shall not be employed in any position other than as a consultant, and shall conduct himself accordingly at all times. That's the scope that was supposed to be with this. Now, moving on down the line. I just gave the city council a week ago a litigation report. Nothing has changed. So I have nothing to report to you about litigation, unless you would like to know that there's now a February 9th day that could conclude the Buckeye litigation. There is and this is public knowledge, there is a hearing on it.
In what way could it, what is happening on February 9th?
There is a motion for summary judgment that